Good morning, everybody, and I hope you're all well on this Monday morning. And I'm sure, like me, you've had a great weekend watching Series 1 of the race to the elections. It's definitely been an eventful few days. But welcome to the Greater Birmingham Transatlantic Chamber of Commerce webinar this morning. Where we are looking at data protection rules are changing and what can you do to prepare. My name's Stephanie Bowes and I'm the International Business Manager here at the Birmingham Chamber of Commerce, and I'm delighted to be joined here this morning by Richard Nicholas, who is Partner for Digital Business at Brown Jacobson. Just a little bit of housekeeping to start with. After Richard has done his presentation, we will go straight into a Q&A. So if you do have any comments, thoughts and questions, please do pop them into the Q&A box below. And also if you do have any technical difficulties today, my colleague Sophie is in the background, and if you do have any issues, please do pop them into the box and she'll be able to help you. And just to move on to our next event with the Transatlantic Chamber of Commerce, this will be taking place on Wednesday the 16th of December. Between 4 and 5:30, and this is your chance to kind of get involved with any of our members who have involvement in international business, and obviously to widen your connections. We do have some sponsorship available for this event, and if you are interested, please reach out to myself or your relationship manager for further details. So without further ado, I'm now going to hand over to Richard Nicholas, who is partner again for digital business at Brown Jacobson. And over to you, Richard. Thank you.
Thank you, Steph. Thanks very much for this. We're going to be looking at international data transfers over the course of the next 45 minutes. You may be aware that data law is changing, and it's changing here in the UK, and it's also changing particularly in respect of transfers across to the USA. So the three things I'm going to be looking at today, if we look at the next slide, are first of all, why this matters. Secondly, we're going to be looking at a recent case called Schrems II and what that means for data transfers, particularly across from the EU to the USA. And thirdly, we're going to be looking at the next steps, what you ought to be doing about that case and what that really means. But first of all, and why does any of this matter? Let's go on to the next slide. You can see that GDPR, so the General Data Protection Regulation, I'm sure most people are aware of it, is a piece of law, piece of EU law, came out 2016, came into force 2018, and it has a global reach. So it puts obligations upon anyone, anywhere in the world who is either established in the EU, so if you're a business established in the EU, or if you're offering goods or services to data subjects, that's individuals in the EU, or indeed if you're monitoring the behavior of individuals in the EU. So for instance, you're dealing with cookies, you've got some way of monitoring those individuals. And what that means is that if you are doing any of those things, or indeed if you're established in the EU, then GDPR puts certain obligations on you, upon your business, and it puts those obligations on you as either a controller or a processor. So, for instance, you're required to do various things, to have in place a privacy notice, to make sure you have a record of processing activity, and to make sure you treat data in a certain way. Failing to do that means that you can be fined by one of the regulators within the EU. It also means that any of the individuals affected could bring a claim against you if you've suffered harm. And because this is EU law, it would mean that you're in breach of EU legislation, which means that if you've got a contract that says you will comply with all relevant laws, for instance, as many contracts do, then you may be in breach of that contract as well. So you might have a contractual claim from someone else. So it matters that you comply with GDPR, even if you're not based in the EU, even if you're based in the USA. And something has changed in that relationship just this year, which we're going to look at today, which is a case called Schrems II, and that concerns international data transfers. And it's worth understanding what an international data transfer is and what it's not. So just to put this into context, we'll take a quick look at the next slide. If you imagine here on the left-hand side, you've got an individual, that's a man or a woman based in the EU, that's the person in blue, who contacts you via your website. You've got your website and they contact you via that website. They want to know more about your information, about your services, what you provide. They get in touch directly and they provide you with a name, address, email, etc. That is not an international data transfer. You are still required to comply with GDPR. You still have all of the obligations under GDPR. You're required to keep a record of processing activity. You're required to give them a privacy notice. You're required to treat their data in a certain way under GDPR. So you've got all of those obligations still apply. However, that's not what's called an international data transfer. So nothing has changed in that relationship. What has changed is where there is an international data transfer, which, looking at the next slide, is between a controller or processor in the EU and a controller and a processor in the rest of the world. So if data transfers from the EU, personal data transfers from the EU out to anywhere else in the world, then that is what's called an international data transfer. Now, it transfers out of the EU, not into it, and it's from a controller to controller, controller processor, whatever that relationship is. If it is transferred, or indeed if it's accessed from outside the EU, that is an international data transfer. And in order for that to be compliant with GDPR, you need one thing, which is an adequate, if you move on to the next slide actually, you're looking for an adequate safeguard to be in place. Now, that adequate safeguard effectively means that the country that it's being transferred to can be treated as if it were within the EU. Now, there are various whitelisted countries that you may be aware of that have already received an adequacy decision by the EU. In other words, their jurisdiction, their data law has been looked at by the EU and has been found to have similar data protection requirements as the EU. It looks after personal data in the same way. And those are that list there: Andorra, Argentina, Canada, the Faroe Islands, Guernsey, Israel, Isle of Man, Japan, Jersey, New Zealand, Switzerland, and Uruguay. There are a couple of countries, well, several countries not listed on that relatively short list, one of which, of course, is the USA, which we're talking about today, and the other is the UK. Now, the UK is not listed because, of course, the UK is currently a part of the European Union. And that membership has effectively been extended by the transition period, which we're in at the moment, and which ends on the 31st of December. After the end of that period, we will no longer be part of the European Union. We'll not be able to transfer data in the same way unless there is an adequacy decision. And right at the moment, this week, for instance, there are discussions about having a relationship between the EU and the UK, and one of the things being discussed is exactly that, is the adequacy decision that would allow for the ongoing transfer of data between the EU and the UK without any further measures. Now, I have to assume, given that the self-imposed deadline for that deal has passed, that there may not be a trade decision, in which case the UK would be in a similar position to the USA. Transferring data out of the EU to a country that doesn't have an adequacy decision, so that includes the USA, includes Australia, includes various other countries, means that you need to have one of the other adequate safeguards. Now, up until this year, there were three for the USA. One is binding corporate rules, which is a mechanism in GDPR, which we can talk about in a moment. Second is standard contract clauses. But the easiest for most US businesses was a thing called Privacy Shield. Now that's the thing that has changed. There was a case this year that effectively removed Privacy Shield, and it was a case called Schrems II. Now if we go on to the next slide, you can see that Privacy Shield is a set of contractual obligations on the data importer in the USA, so the person importing the personal data. And the idea was to give that importer the same sort of contractual requirements as it would have under EU law. And going to the next slide, that has been removed. And you may be wondering, well, this is a case called Schrems II. You might have missed Schrems I, and this is a sequel to something. You may be aware that this has been a while in the making. So back in 2000, this was recognised as an issue, and there was a mechanism put in place with the USA called Safe Harbor. Safe Harbor was a voluntary scheme in the US that allowed businesses to sign up and effectively confirm for themselves, sort of self-assessment type process that said we will comply with EU law on data protection. Now there were no checks, there were no balances on that, and Max Schrems brought a claim specifically against Facebook back in 2013, and as a result in 2015, Safe Harbor, that mechanism, was invalidated by the European Court. Clearly, businesses needed to carry on passing data to the US, and as a result, 2016, this new mechanism called Privacy Shield was established, whereby businesses could both establish that they were compliant, they would go onto a register, and there would be some basic checks to make sure that they had the right wording at least in place. However, there was very little by way of checks that actually they were complying with the wording that they put in place. As a result, Schrems II, which was a second case that came before European courts earlier this year, Privacy Shield was invalidated. So that is no longer effective. So what does this mean? If we go on to the next slide, you'll see this is the chap, Max Schrems, sitting at his computer redacting documents, which is, I'm told, his favorite pastime. Why did he do this? Well, none of your business. None of your business is his campaign. And it has a very serious intent, really. It's looking at the transfer of personal data to the US, and in particular, the ability of the US government to get hold of personal data and to use it for its own purposes. Specifically, there's two bits of legislation that allow the US government to do that. One is Executive Order 12333, which allows the US government to effectively tap into and recover data directly from source as the data is transferred to the USA. And the second is a thing called the Foreign Intelligence Surveillance Act, or FISA. Section 702 of that act allows the US government effectively to require communication service providers to pass personal data to the government. And that affects quite a lot of large businesses in the USA. It includes Amazon Web Services, Cloudflare, Dropbox, Facebook, Google, Microsoft, Verizon. So a lot of the large businesses in the US could be required at any time by the US government to hand over personal data. And actually, as a EU or indeed UK citizen or non-US citizen, there's very little that you can do about that, which is why Max brought this claim, and why, as a result, the Privacy Shield mechanism for transferring data across to the USA is no longer effective. So what does this mean? Again, go on to the next slide. Now that Privacy Shield is invalidated, it means that effectively it's invalidated immediately as a result of that judgment. There's no grace period or anything like that, which means that any transfers taking place since July of this year that are reliant on Privacy Shield are potentially in breach of GDPR. Now, there are alternatives to the Privacy Shield, one of which is a thing called binding corporate rules. It's basically where a an organisation can set out the rules and get those rules approved by a regulator. The problem with binding corporate rules is it is horrendously expensive. It costs in the region of £250,000 to get one of those in place, which is clearly a huge cost. It is also very time intensive because you're actually requiring a regulator to sign off on those rules. The more likely and better solution for most businesses is to use what are called standard contract clauses. What these are clauses that have been agreed by the European Union as putting in place an adequate level of protection for the data importer, for the person in the USA. Now, that of course requires a contract. You don't always need a contract in order to transfer data between controller and controller, but it can be a good thing anyway, not least because it can set out, the contract can then set out the basis of that agreement and who is responsible for what and whether indeed both parties are responsible for each other. So it requires a contract. But here's the thing. Standard contractual clauses also require, and have always required, an assessment of whether the law of the destination country, the USA, gives adequate protection. Now, given that the Schrems case looked at the jurisdiction of the USA, looked at the laws of the USA, and decided that the USA didn't give adequate protection, there is more than an argument that at least standard contractual clauses may not be effective for transfers of data to the USA. They may not give adequate protection by themselves. So what does that mean? Okay, looking at the next slide. It means that we're reduced to seeing what else there is, and really there isn't very much. There is an exception, but it is a very narrow one. Article 49 of GDPR allows transfers of data outside the EU where you've got both explicit consent, so you must tell the data subject that first of all their data is being passed to the US and tells them the risk of the US government having access to that. It must be necessary for a contract and it must be in the interest of the data subject. The killer, however, is that this is only for occasional and not repetitive transfers. And the example given is for booking a hotel. So if you were booking a hotel in the USA, someone was looking to book a hotel or even a garden center to run a conference from, then you might well be able to do that without any adequate transfer in place because it's a one-off. It's unlikely to provide a solution for ongoing transfers, for businesses that share data, for cloud service providers based in the USA, for businesses that share data with their affiliates in the rest of the EU, for instance, for businesses that have employees across the EU and the USA and therefore wish to transfer data. So what does it mean for them? Looking on to the next slide. It means that for now, standard contract clauses are the only practical way of dealing with those transfers. Standard contract clauses need to be accompanied with an assessment. Now, in practice, what this means is you're going to have between the EU business and the US business, first of all, a contract where you might not have had a contract before. As I've said before, there may be some advantages to that anyway, but you will need a contract in order to incorporate the SCCs, the standard contract clauses, because they must be incorporated in writing. Given the assessment, however, that's also required, you're likely to also need some additional contractual provisions that deal with, for instance, encryption of the data to deal with the executive order. You're going to need some additional contractual provisions that give promises from the recipient in respect of requests from the US government in respect of the other bit of legislation, the FISA. You're also going to have to carry out a certain amount of an assessment of the risk to the data subject. Not all personal data is the same. Personal data could include things like your shoe size, various things like that. If the US government got hold of that data, would the data subject really be at risk? Probably not. But if it includes data about a person's beliefs, their family, their finances, data that could be used against them or to prejudice their interests, then actually possibly the risk is greater. And for that type of data, it might be worth considering an alternative to a transfer to the US, at least for the short term. Longer term, looking at the next slide, longer term, there's a good chance that this problem will be solved. There no doubt will be a solution to this, the dropping of Privacy Shield. After all, we had Safe Harbor before. After Safe Harbor, there was the creation of Privacy Shield, which is a new mechanism. There's been various discussions at an EU level as to what might replace Privacy Shield. Could there be a new mechanism between the EU and the USA? One of which was placed before the European Union just a couple of weeks ago, was the slightly unfortunately named EU Cloud Code of Conduct, suggested by a number of cloud service providers. So the EU COC was presented, puts in place similar levels of protection for potentially for cloud service providers in particular. Hasn't yet been adopted by the EU. It might be a solution, it might not. Until then, it's likely to be worth checking that you're checking your contracts, particularly contracts that involve the transfer of data across from the UK to the USA, and looking at what provisions you might have in those contracts in terms of transferring the data. If you haven't got anything yet, then you're likely to want to put something in place. And in particular, on renewal of any contract, it's going to be worth putting these changes in place. And in the meantime, you may well want to vary your existing contracts to deal with the sorts of obligations that you're going to want from a US recipient of personal data. I'm happy to answer any questions that we might have over the course of today. I was going to say the one thing, anyone who's interested in this, I've left my LinkedIn details on there as well. There's a couple of groups. I do have one of which is DPO Resources. The other is Simply Digital Business. On those, we will be looking at updates on this area, because it is one where we're anticipating reasonably soon some guidance from the UK regulator in particular, but also from the European EDPB, which is the European group of regulators on specifically this issue. So that's all I was going to say in terms of throwing information your way. Very happy to answer any questions that anyone might have on transfers of data more generally.
Thanks, Richard, for a great bit of advice and guidance on this. We do have one question that's just come in, and this is from Stephen Brooks, and he's asked, how does this impact international partner schools, Commonwealth, sharing information?
Okay, so international partner schools, I'm assuming that might involve schools inside the EU and outside the EU. And potentially also the UK. Now, the UK has its own challenges and issues coming up. Let's say with the end of December, there's a chance that the UK may well leave the European Union without a deal, without an adequacy decision, in which case the UK would be in a similar position to the USA. Now, of course, the Max Schrems case was specifically on the USA, so we haven't had a judgment that says the UK law doesn't give sufficient protection to personal data as we have in the USA. But there is a risk that could happen, in which case we will be in that situation. So in terms of international partner schools, I don't know where they are in the world, but from the end of this year, there will be a new GDPR, which is a UK-based GDPR. That will have similar terms to the European Union GDPR. And in respect of transfers of data, that list of adequate countries where there's been an adequacy decision, the UK has said it will keep to the same rules. So in terms of transfer of data from the UK out to those out to various of those countries, that will still apply. In respect of transfers from the UK out to countries not on that list, such as Australia, the same requirements will be there as are currently there. In other words, you'd still need standard contract clauses. In terms of transfers from the EU to countries that are not on the list, again, the same things will apply, but transfers across to the USA specifically, if they had been reliant on Privacy Shield, you will now need standard contract clauses. One of the things that we've put together for a lot of very large businesses that have got a lot of affiliates, for instance, is put in place an agreement that deals with all of the different variations and all of the different types of transfer that there could be. Now, that is called an international data transfer agreement. That might be the sort of thing that a large organization or a large cluster of organizations, such as international schools, might want to consider. And that would cover things like the transfers of data in and out of the EU, in and out of the UK, from controller to controller, controller to processor, processor to processor, and all of the various different transfers that there might be. But from a practical position, that's the sort of agreement that you might want in place that deals with just everything. And then anyone who becomes a partner school, a bit like any company becoming an affiliate, would effectively sign up to that same agreement.
That's fantastic. And I think that's very much helped Stephen. Okay, so next question is from Mark Friberger Possel, and he is asking, Microsoft are claiming that cloud data for UK organisations on only stored on EU-based servers. Do we take their word for it, or are we expected to confirm this?
It's a good question, and there's a related. I'll answer that, but I'll also answer a related question, which is actually the storage of the data. So where the data is actually stored is not the key issue, because even if the data never leaves the EU, but is accessed in the USA, or is accessed in another jurisdiction, that still counts as an international data transfer. So if the answer from Microsoft is it's always on EU servers, and I'm sure if Microsoft is saying that, that's probably true, that's part of what you need. It's not actually the answer that you need. What you need from Microsoft is that it's stored in EU servers and actually only accessed by Microsoft staff within the EU. Now, if that is the case, then yes, that would give you the protection you're looking for. The point is, if those same servers were accessed by Microsoft staff in the USA, or was maintained, was looked at by Microsoft staff in the USA, then that would still count as an international data transfer. So if you like, the response from Microsoft is part of what you're looking for, but it's not the complete answer. So I would be pushing for that extra confirmation as well.
So just on the back of that, he's asked if data servers are assessed by Microsoft staff who broke the law.
If data servers are accessed by Microsoft staff who broke the law, okay. It's always an interesting one. Because then it comes down to, well, what is your relationship with Microsoft? If you're if your relationship with Microsoft is that they are a processor for your data, then you will be putting various obligations on Microsoft as part of your contract. If they breach that contract because they don't do the things that they said they should, or that they said they would, then it is effectively them that are in breach, provided you made sure, of course, that they're aware of their obligations. A company like Microsoft, I'm sure, will be completely on top of this. They will have looked at this and they will be giving training to their staff. The concerns more often, frankly, are not the Microsofts of this world or the Googles of this world, but more like the small cloud providers in the USA who might not have even come across this area or might not have considered it in the same way. If the Microsoft staff break the law and they also break your contract, it is Microsoft's problem. You do need to make sure, though, that you have the right obligations in your contract. And from the regulator's perspective, the question you would get from a regulator is, where is your accountability? So where is your, what have you done to make sure that your contract is complied with? And if in reality you've done everything that you can, you've got the contract in place, you've made sure they sign up to it, you've looked at what Microsoft are doing with the data and you've got satisfactory answers, then it's going to be very difficult really for a regulator to find you at fault. Most of the very large IT providers, such as Microsoft, such as Google, such as Amazon, have got EU-based servers and more importantly, an EU-based business precisely for that reason. So it is possible to deal with those companies based in the European Union only.
Fantastic. Okay. And third question, Kerry Leon from Grid Edge. How does the invalidation of Privacy Shield impact on email services held in the US?
Mm-hmm.
We use an email service to send notifications to our clients, which means their email addresses are held in the US. It's not necessarily as harmful as personal information, but much more concerning than shoe size.
Yes, I think I think you're right. I think it is more concerning than shoe size. I don't know that it's not personal information. It's email. If it is email notifications. First of all, it is their email address. Potentially, I suppose it could be the information within that email as well. So only you will know the risk to those clients. So an email service provider is most likely to be a processor. What that means is you will want processing terms in place with that provider in any case. There's a requirement. For what it's worth, Article 28 of GDPR sets out the requirements that you must put in place with the processor, including the processor keeping that information confidential and secure, and all of those sorts of requirements. You will need that anyway, so you would need that wherever they were based. The thing that you will also now need with them is the standard contract clause. That is a data controller to data processor contract clause. I would suggest having that as a variation to your existing contract. And the justification for that is that both you and actually your service provider are effectively need to sign up to this in order to comply with current law, current EU law. Now, of course, it is an obligation on both parties. It's an obligation on you and also on the processor. Being based in the US, they may be less concerned with complying with EU law. They may see it as less of an issue, but it is a reason for varying your contract now. So I think you should be looking at putting in place a variation to that contract, and unless you've already got standard contract clauses in place. Some email providers have had this in place anyway. Not everyone has been reliant on the Privacy Shield So some contracts will already be covered.
Fantastic. Okay, so well, we're well within time. So if anyone does have any further questions, they want to pop anything in now. But yeah, and I guess if not, if you could maybe leave us with a final piece of advice for today, Richard.
Okay, I think the advice for today, particularly for US businesses, is just to look at where you are reliant on Privacy Shield. So if you have signed up to Privacy Shield, know that it is no longer valid. I have had some inquiries to say, well, should we just renew it anyway? Should we just carry on with it because it's better than nothing? It probably isn't much better than nothing. What you are likely to need is the standard contract clauses in place. It is worth, if you haven't done this already, getting a contract in place that deals with that transfer of data. It becomes slightly more complicated if it is also UK, US, or even EU, UK, US, because that contract is also going to have to deal with both Schrems and the transfer of data to the US, and also potentially from the end of this year, Brexit. So the one thing I suppose to take away is just to check how you are transferring data. If you have got US companies involved, just check that if they had Privacy Shield, they've got something else. Check what your contract says, and if it doesn't have that level of protection right now, it's worth getting it in. Get it in a variation, or certainly get it in at the next renewal.
Fantastic. Thank you very much for today's informative session, and thank you everyone for joining us today. The event will be uploaded onto our YouTube channel later on today, so you can watch again if needed. But if you do have any further questions, please don't hesitate to reach out to us or your relationship manager, and I hope you all have a great week. Thank you very much.
Thank you, everyone.